Thank you, thank you, thank you. It's good to be here. Beautiful space. Wonderful. Good people. Old friends, new friends, wonderful. The topic today, of course, is as we expand into the future, there are legal ramifications and guidelines that you must be aware of. And I've invited my friends here. These are experts, going to help us. But first, I want to just set the stage a little bit because I am also a crypto lawyer and technology lawyer myself. I'm a technologist and also a legislator. And it's important to remember to all you people launching products and projects, the purpose of technology is to help humanity. From the very first time someone picked up a stick to knock an apple out of a tree, that was the first use of a technology to make our lives better. So I encourage you to always go deep and make a use case that is actually useful. So to that end, I have three panelists here: Alex Yatchemsky, Christine Allen de Levin, and Yasmin Parsafar. So please introduce yourselves, my friends.
Great intro. Thanks, Ben. I'm Alex Yastrzemski. I'm head of the corporate and transactional group at Cole Freeman and Mallon. Cole Freeman and Mallon is primarily a funds firm. It's a crypto funds firm. My practice is representing funds in their investments in the crypto and AI space, as well as representing the startups themselves in order to lure in those investors into their vision and into the future of the products they're developing.
Hi, everybody. Really nice to see you all here. So I am Christine. Before I tell you what I do, I'd like to tell you a bit about who I am. I'm known, or like to describe myself, as a simplifier and as a go-further maker. And yes, I am an attorney, and I promise these things can work together. My overall quest is to make the most purpose of the human brain and bring it to the most use and better use of its potential. So 20 years back, I stepped into law with the purpose of defending expression and opinion because that's where I believe decisions are made. I worked for the UN to scale up those values to the best of its potential. And then I founded my law office, a side law office here in the Valley, dedicated to European tech and IP services. And because I believe IP and tech law is really a tool for thriving in innovation and for human progress.
Hi, I'm Yasmin. I am also an attorney and I'm with the law firm Sheppard Mullin. My practice focuses on intellectual property disputes and advice and counseling. So that includes patents, trademarks, copyrights, trade secrets. And I am the co-leader of our firm's blockchain and fintech team, and I also help manage our AI team.
Wow, some hot shots. Big time lawyers here. Now, we're going to create a hypothetical. And going back to what I said before about use cases that help humanity, we all know that people are overworked and underpaid and stressed. And so our hypothetical scenario is there's a founder of a company who aims to solve that problem. And the company is called IntelliEye. And what they do, they make AI agents. They make AI personas that do your work for you. And they sell them to individuals and to companies, and they're rolling out. And by the way, this came from an actual person I met, a CEO of a major company, said that we should anticipate 2-day work weeks within the next 2 years. In this very process. So this is real. So first off, though, IntelliEye, they need to raise money, and they want to use tokens to raise money. So this takes us to Alex, the tokenomics expert, fundraising extraordinaire. What do we do?
It's a great point to start. Early stage, one founder, two founders, a group of founders. If you've got an AI project with a token component, you have a number of options. Let's assume you're very early stage, you have a viewpoint of where you'd like to get to, and you have a plan on developing that tech. You can go out to the investor market and start finding aligned investors that are interested in what kind of work you do. There are a number of factors that will help you raise those funds. There are a number of factors that will help you remain independent of investors in those initial stages. But one commonality, other than a few very small projects, is that you need that seed funding. And the token option gives you a number of avenues in order to raise that seed funding, even in the US, where tokens are deemed to be securities. In addition to the traditional startup methods of raising capital, selling common stock, selling preferred shares, convertible notes, other vehicles, when you add in the crypto component, things can happen. If your crypto component is an NFT and you have a captured community already waiting for your launch in the Intella AI space, you could, in theory, go out with an NFT placement and solicit your community for seed funding. That's a great avenue, but it's one that not many projects have. They don't have the community, they don't have the NFTs, and they definitely haven't developed the token and its functionality with an AI module yet. So to get that first step started, one good place to go is to do what is called a token offering. If you issue a token and it's ready to launch and you sell it, you're going to be square in the securities regulatory regime, and you're going to need an exemption such as Reg D, Reg S. Those are available to you. We have a number of Reg D token offerings that we work on with clients all the time, and we've forged that path with the SEC. Short of that, you can go out with a traditional seed round raise, like a SAFE note. That SAFE will give your investor the opportunity to participate on a converted basis in a future preferred round. But your investor is really interested in Intella AI's AI agent model. And that agent model requires a token component, whether it's on the back end or whether it's something that the community interfaces with. There are a number of avenues that that token can fit into an AI model like that. But regardless, if that token is a key component of your platform, you may find investors, such as the ones that CFM represents on the VC side, that is interested in those tokens when they launch. Since the SEC views future tokens as securities, the common model that has developed over the past 5 years is to structure your seed round with an equity safe in which the value of the investment is represented. There is a token warrant to the side, which, like the safe, is conditioned upon certain things happening. If there is a token launch at some point in the future, that warrant will allow the investor for a de minimis amount, not tied to their investment, to participate in an allocation of that token round because they funded its development. How the company navigates the regulatory requirements for developing a token, marketing it, and selling it in the US and abroad is the company's problem. The investor will trust the company and its lawyers to navigate that regulatory regime on its behalf. But very often, to the tune of 90% or more of these projects that we see at CFM, that warrant allows the company to find a jurisdiction that is friendly to token issuances, that taxes them in a way that makes sense for the founders and the other stakeholders in that token launch. And with that seed funding, the development company can do a number of things. It can develop its token platform, the smart contracts underlying the AI focused token. And it can also develop a team in order to support, launch, and manage that token down the road in the future. That launch will include a community outreach, and it will also include an outreach to the investors who funded the development and are to get an allocation of those tokens at the launch. That's pretty clear.
Yeah, I'm negotiating a token warrant right now.
Yeah.
And one of the key clauses we're fighting over are excluded tokens. And the investor wants to have it their say, and the other company wants to have it consensus based. Forget about the panel. What should I tell my client?
Is your client on the investor side?
No.
They're the company. They're issuing the
They're
warrant.
receiving it. Yeah, receiving
Yeah,
it.
yeah, they need to have full control over that project. They can't have an investor wagging the dog. Most investors, and there are arguments that a company can make to keep an investor out of their inner workings. From an SEC regulatory standpoint, the more rights that, let's say, a lead investor has in that seed round or in that pre-seed round, the more likely it is going to be that an audit from the SEC or the IRS will view that investment as something more than an arm's length transaction. Companies are already in a strong position when they have negotiated a safe with an investor, which is very company friendly, and they're really missing out on that token warrant. So they have to be careful that they have the ability to navigate the future of that token development and launch. Because if they start honoring the interests of an investor around that launch, then all of a sudden that launch is a lot more than a community-focused token or a admin-backed token for an AI platform. Now all of a sudden it is an investment vehicle for that investor, and you do start to run right up against US regulations.
Amazing. Alex, wonderful. Thank you. So now we've issued our global token raise. We are flush with cash. It was the biggest STO, ICO token offering in history, bigger than EOS, and now we're ready to roll. So we want to roll out through Europe first before America. So Christine, as we approach the EU, what are we looking at here?
All right. Thank you, Ben. So first of all, thank you for this really creative imaginary case, because in fact, it's far from being imaginary. It's really raising the true questions that I usually get from the clients. So let's say that these most important questions will be like, what's the AI regulation? Because that's where we start from when we go to the EU. What does it prompt Intel AI to do right now? And then on the longer term, what is the EU Act going to be an enabler or a stopper for Intel AI and for all of your projects here? So again, I see law as an incredible tool to make things happen and terrain for innovation and creativity. So that's my scope on this. Now, what is the EU AI Act? For those of you who are not familiar with this piece of legislation, it is the first ever legislation in the world fully dedicated to AI only, which sets a set of compliance rules for any form of use of AI in the EU. It is the result of 4 years of discussions, and I should say 4 years of very heated discussion. Its enforcement or its applicable date is going to be mostly summer of 26 for the most part, and some parts a little earlier and some parts a little later. What's the goal of the Act overall? It's to promote and boost the current development of AI in a human, respectful way. And I will like to take this further and say in a human, beneficial way. Now, what does it prompt you guys to do right away, or Intel AI to do right now? Pretty much nothing, because it's not enforced yet. Now, if you're proactive and EU is going to be your market, you're going to want to be ahead of the game and look at mainly 3 aspects. 1, assessing the risk that Intel AI presents for human rights, democracy, and environmental sustainability. Those are the values that are in the balance test for the AI risk assessment. Now, in the case of Intel AI, I'm not leaning for it to be in the prohibited list, but I'm definitely leaning for it to be in the high risk list. That regime will start being effective summer of 2027. We have some time to prep. Now, how do you prep? Easy. Documentation, transparency. Don't lose track of your data. Keep documentation of all your structures and all the steps in the way you build your pipelines and models, and of your data sets, data collection. Don't lose track of that. Second of all, transparency. Tell your users what you do, why you do it, and how it will impact them as human beings. Now, on the larger scale or longer term, is the EU Act going to be an enabler or a stopper for this project or many others? A stopper, certainly not. I'll just start by telling you this. The document is 459 pages. 459 pages. What does that tell you? That tells you that there's been a lot of political controversy over this text and still will be. That tells you that there's going to be a bunch of loopholes and turbulence to be expected. That tells you that no one is going to read this text the same way and that the interpretation is going to be absolutely chaotic. So is this piece of legislation ready to be enforced as it is today, or when it's actually planned to? My answer is no. It is not mature enough at this point to be implemented as is, and I insist as is. Now, is this something that's to be seen positively or negatively? I see this as a positive because this piece of legislation is an enabler. Why? First of all, because it is groundbreaking and it sets the principles for future legislation. Those principles, I like to focus on them as being the risk-based assessment, the risk-based approach, self-documentation, and human control. And I'll get to this point in a minute. Now, it is expected to have what we call the Brussels effect, which is the ripple effect that GDPR had in the world of privacy. This is going to shape the market, the practices, and serve as a blueprint for all further legislation. So again, as is, not ready to go. Now it calls loud and far to all of the AI industry operators, all of you, to participate in drafting the codes of practice. The Act says that these codes of practice need to be out by March 25, January 26 at the latest. That's tomorrow. That's the real deal. That's where the real shape of regulation will be designed and conceived. And that calls for all the industry's input. If we're not part of it now, it's going to come to us in a form and shape that we don't like. So I think this call is where the AI Act has the most to give to the industry, to have an opportunity to be part of it, not fear it, but actually invest it. Now, while you do that, I want to give you some thought about a core principle that is behind this piece of regulation and the future regulations to come. Today, the Act has for only railguard against AI damage to the humankind, human control. Human control is the only railguard as is in the 459 pages and the four-year discussion. Now, is that enough? Is that adequate? To my knowledge, humans make mistakes. They have biases. They misunderstand. They forget. Are all humans suited to control AI? Should the human controllers be licensed, certified, trained? Should there be rules against concentrations and monopolies? Those are all the open questions that you are asked to answer in the codes of practice. Now, while you think of this, I'll leave you with one last example that I like to refer to, which is very old, but still relevant. HAL 9000. HAL 9000 was a robot, human manufactured robot. It was given two human instructions, two prompts. One, always tell the truth. Two, never let our spaceship crew know the true purpose of our mission. What did HAL 9000 do? Killed the entire crew. Why? Because that was HAL 9000's next best. Its only option to actually combine both of these contradictions given by the human instruction. So, has the human control been able to avoid for this catastrophe? Should another form of control be able to avoid this catastrophe? I'll leave you with that.
Well, that was scary. But at Atelier, we're going to make the best virtual workers work on good things. We won't kill our hosts. But what I extracted from you, Christine, was that the process for the rulemaking in the EU is still a porous entity that we can enter and influence, right? Okay, perfect. We'll talk more afterwards. Yeah? Now, Yasmin, we're in the EU now. We changed all the rules. We dominate the EU. And now we're coming home to America. We want to dominate America and everyone work 1 day a week. So what are we looking at?
Okay, so regardless of whether this company is developing its own AI tools or using third-party AI tools, what it should start with is an AI governance board or team within its company, and they should have several different jobs, which include updating their employee agreements on an AI acceptable or restricted use policy, employee training on the use and development of AI, as well as monitoring and compliance and updating third party and vendor agreements. And this is why. So, depending on what you are doing with AI, and this applies to any company, there are many different legal implications. So, you can think of several different buckets. You have the development of AI tools, the training of AI tools, your inputs into the AI program, your outputs of that program, and then also your company's marketing and advertising and consumer communications about that AI tool. And each one of these different uses has various legal implications that can have really big effects on the company if there are compliance issues. So I'll give you examples for some of the different buckets. So with respect to training the AI model, there's various issues, including, for example, data privacy concerns. If the model was trained with data that was collected, used, or maintained in violation of various data regulations, that can have a profound impact on the company that is using this tool, or and this could be a third party that is licensing this tool. For example, the FTC has issued actions against at least a couple app developers for data privacy violations with respect to training and use with their AI models. And there have been at least 2 orders of algorithmic disgorgement for these violations, which is basically an order saying that any model that was developed using that data that was improperly collected or used or maintained needs to be disgorged. So you can think about, if you're the company that's developed that model, that can have significant financial repercussions for you, and also if you've been licensing that model. And the orders are very broad. It's like the language is something like any work developed using this data. So that's just one example of a huge problem with respect to training. There's others which you may have seen in the news with lawsuits related to copyright or breach of contract violations. For example, with the open source source code for the code generating tools. So those are just examples for training models. And then with respect to inputs, you can have various issues of trade secret violations. And there have been a couple of cases on this with employees improperly allegedly putting the company's trade secret information into a third-party tool. And a lot of these tools in their terms of service say, whatever you input here, we can use it for various purposes. So if you are not restricting or controlling your employees' access to some of these tools and you don't understand the terms of service, you could be providing the tool provider with highly confidential either trade secret information or personal customer data that can also result in data violations, because the company has obligations under various regulations with respect to their customers' data. So if your employees are putting it into the tool, that can be a huge problem. Another problem with your inputs into these tools, there's IP issues. Some of these terms of service say whatever you input into the tool, you give the tool provider a license, for example, or you don't even own the IP that you input into the tool, and you've just given up your rights to that. So if the company doesn't understand or control how their employees are using that, they could be giving away IP rights as well. So that goes into the input bucket. And then you have the outputs issue. And some issues that can come up in outputs are various IP infringement issues. So if you're using a code generator or a something that generates content that you guys are using in marketing, or it could be you can be using a generative tool to create a logo for your company. These tools, a lot of them are trained, as you know, on publicly available information. So the output can be very similar to somebody's protected IP, and you can get an infringement lawsuit against you if you're then using that output, for example, in your commercial marketing materials. And there's no like defense to, oh, I was using a third party tool. It's not my fault. In fact, several regulators have come out and said that ignorance is not a defense and using a third party tool is not a defense. If you're using these tools, you're responsible for the consequences of them. So that's why it's so important, you know, to have this AI governance team that controls your employees' use. And one thing that can be incorporated is like an acceptable use policy. So we do this a lot for open source use as well. You know, you can have like a matrix that's like, if you want to use this open source, you can use it for these purposes, but not for these purposes, or like this one's prohibited, you can never use it. And it really, these are like bespoke policies because it depends on what the company's business is, what they're using the tools for, what kind of tools they want to use, and how they're going to use them. And then, you know, the governance board can use that to create like a policy that's best suited for this company and make sure that they are really managing their risk with respect to these tools.
Well, any libertarians in the house? There's too many rules, right? We pay a lot of money in legal fees in my company, IntelliAI. Millions of dollars to pay these three firms, or two firms. Yasmin, quick follow-up here.
Yeah.
The term algorithmic disgorgement, that is really scary. So let's say, for instance, my IntelliAI's most popular product is our robot surgeon. We do brain surgery, eye surgery, everything. And it was trained by a few doctors and they took their patient's data and plugged it in, and we built it out. Any issues there?
Yeah, so if the data was collected or used in violation of any data privacy regulation, and it could be, I think in one of the cases that it was with respect to use, and they didn't like properly disclose to the consumer how the data was being used. One of them was a biometric app. It had to do with biometrics. It was an app. The FTC came down on them and ordered disgorgement of any model based on that data. And the problem with that is, one of the problems with that is it's so broad that complying with that, you basically have to throw out everything, because if you're familiar with this technology, there can be multiple iterations, right? Because it's constantly being trained. So how do how do you like identify the model that was using that specific data, if it had to do with specific data? And it basically taints all of it if you look at the orders from the FTC. So it's a very broad order that can have profound impact on a company. And the FTC, the EEOC, many different regulators are really in tune right now to all the issues, and they're going to be, we expect more regulation and enforcement, and so companies need to be aware of that.
It's hard to make a buck these days, isn't it? Lord. So we have a few minutes left. What's some questions from the audience?